ช้าวันนี้เมื่อเวลาประมาณ 10 นาฬิกาที่แผนกคดีอาญาของผู้ดำรงตำแหน่งทางการเมืองในศาลฎีกาได้มีการพิจารณาขององค์คณะผู้พิพากษา 9 คนนัดตัดสินคดีใหญ่ของนักการเมืองเฉาที่เชื่อว่าโกงกินโครงการยักษ์กว่า 70,000 ล้านบาท
ผมเชื่อมั่นในกระบวนการยุติธรรมมาตลอดนะไม่มีปัญหาครับ
การทุจริตและประพฤติมิชอบของนักการเมืองและข้าราชการระดับสูงในเมืองไทยพบว่ามีเพิ่มมากขึ้นทุกปีก่อให้เกิดความเสียหายอย่างใหญ่หลวงต่อประชาชนและประเทศชาติล่าสุดมีการฟ้องร้องดำเนินคดีเอาผิดนักการเมืองกลุ่มหนึ่งจนมาถึงขั้นตอนที่แผนกคดีอาญาของผู้ดำรงตำแหน่งทางการเมืองในศาลฎีกาได้นัดไต่สวนแล้ว
5, 4, 3, 2, 1
Welcome to the Criminal Division for person holding political position of the Supreme Court. The Supreme Court is the highest court in the Court of Justice. There are a total of 11 special cases divisions for the benefit of adjudication and decision on particular cases that require special expertise. The Criminal Division for persons holding political positions of the Supreme Court was established in accordance with the Constitution of the Kingdom of Thailand to increase the efficiency of judicial actions of corruption and misconduct of high-ranking politicians and government officials causing damage to the nation. Those holding political positions include the Prime Minister, ministers, members of the House of Representatives, senators, other political officials, and also other people who are principals, instigators, or supporters. The scope of powers in the criminal proceedings of persons holding political position includes a case with the basis of the case is an accusation of a person holding a specific political position as provided by law. The judges of the Constitutional Court, holder of position in independent organization, or the governor of the Auditor General has acquired a suspicious wealth, committed corruption, or intentionally performed the duty or exercised functions in breach of the provisions of Constitution of the provisions of laws. A case in which an independent inquiry panel considers that a member of the National Anti-Corruption Commission has circumstantially acquired suspicious wealth, committed corruption, or intentionally performed the duty or exercised the power contrary to the provision of the Constitution or the provision of laws. A case where a person is allegedly a principal, an instigator, or a supporter of the commission of an offense, or a person who has given offers to give or agreed to give property or any other benefit to those persons mentioned earlier for inducing an action, an inaction, or a delay in an action which is unjustifiable in the performance of the duty.
งานนี้ผมให้ท่าน 20% นะครับ
ตกลงตามนั้นแต่ว่าให้เวลาแค่2 เดือนนะ
ไม่มีปัญหาครับท่าน
A case in which a person under requirements of laws has intentionally failed to submit an account showing particular of assets and liabilities or intentionally submitted an account showing them with falsity or concealed fact which should be disclosed where circumstances make it reasonable to believe that such person has an intention not to indicate sources of asset or liability. Hello, I am Judge. In the Supreme Court, the criminal proceedings of person holding political positions have the following steps, starting from filing a complaint by the person having the power to sue and prosecute, which is the Attorney General or the National Anti-Corruption Commission (NACC). In submitting a case to the court, the Attorney General or the National Anti-Corruption Commission obliged to notify the accused to come to the court as well. In the case where such person fails to appear before the court and there is an evidence satisfying the court that an arrest warrant has been issued but such person has not been arrested, or the non-appearance of such person is prompted by dilatory attempts, or the non-appearance on the appointed date is without any reasonable excuse, the court can accept the case for trial and conduct the trial in the absence of such person.
แจ้งไปว่าติดงานรับรองแขกต่างประเทศไม่ว่างไปหรอก
Upon receiving of case files, the court official shall check a complete complaint and documents before presenting to the President and Justices of the Division. After a fundamental review of the case, the President of the Division shall inform the President of the Supreme Court. Did you know that a quorum of judges cannot be predetermined? There must be a secret ballot only. The President of the Supreme Court shall expeditiously convene a General Assembly of the Supreme Court for the purpose of electing 9 justices made on a case-by-case basis to constitute a quorum of judges consisting of justices who hold office not lower than that of justice of the Supreme Court or senior judges who have previously held office not lower than that of justice of the Supreme Court. Each election shall be made by secret ballot. After that, the President of the Supreme Court will announce the list of judges to the Supreme Court within 5 days from the date of general meeting in order to provide the parties with knowledge and have the opportunity to object. Once the panel of judges has been made in each case, a date will be scheduled to select a judge in charge of the case and consider the indictment or a petition filed with the court. Then the appointment date of hearing for the petition or indictment is set and will be notified to the parties through the writ of summons. On the hearing day, the quorum of judges will explain the case to the defendant or the accused and inquire about the wishes to appoint a lawyer and acquire the testimony in which details will be recorded. In cases where the defendant or the accused does not come to the court on the day of the first hearing for any reason, it is considered a denial. And in the event that the court has sent the writ of summons and a copy of the action to the defendant or the accused lawfully, but he or she did not come to the court shall issue an arrest warrant and have the concerned person to monitor or arrest and report the results of the follow-up arrest periodically. If the defendant or the accused cannot be arrested within 3 months from the date of issuing the arrest warrant, the court shall adjudicate the case in the absence of him or her without disqualifying his or her right to set up a lawyer to act instead. In a case where the defendant or the accused refuse or does not testify, the court will set a date for the examination of evidence and schedule a further hearing. In the case where the defendant pleads guilty, the court may request the evidence for further investigation. The trial shall be conducted on the basis of the inquisitorial system in order to obtain the facts arising in the case. In this regard, the inquiry file of the NACC or the independent investigators, as the case may be, is used as the basis for consideration. And for the sake of justice, the court has the power to inquire for additional facts and evidence. Moreover, the trial and inquiries of evidence shall be conducted openly. A video recording system will be operated in every trial. All judges constituting the quorum shall successively prepare an adjudicatory opinion in writing and shall make an oral statement at their meeting, and mutual discussion shall first be carried out at their meeting before passing a resolution which requires the majority of votes to become an order or a judgment of the court. The judgment of the court shall be appealed to the General Assembly of the Supreme Court within 30 days as from the date on which it is rendered by the court. In the case where the defendant who is not put the custody appeals, the defendant may submit an appeal only when the defendant appears before the court official at the time of submission thereof. The case where the appeal of the judgment is not submitted is final from the date the court has rendered or deemed that the judgment has been rendered. However, if it is the case that the court has sentences to death or life imprisonment, the court has obligated to refer the case to the general meeting of the Supreme Court for consideration as an appeal. The decision of the appeal by the General Assembly of the Supreme Court shall be made by a quorum of judges consisting of 9 judges selected by the General Assembly of the Supreme Court from justices of the Supreme Court holding office not lower than that of presiding justice of the Supreme Court or senior judges having previously held office not lower than that of presiding justice of the Supreme Court who have not tried such case before. Such selection shall be made on a case-by-case basis and by a secret ballot election. The decision of the appeal by the quorum shall be deemed to be the decision of the appeal by the General Assembly of the Supreme Court and is considered the final. If the perpetrator thinks of escaping when a case has been filed or during a trial, a statute of limitation will be interrupted from the date of filing. The Criminal Division for Person Holding Political Position of the Supreme Court has been operating since November 1, 2000. Its organizational structure is set up similar to an ordinary court, including the President of the Division as the highest authority, the Justice of the Division as a judge performing necessary work at the time when there is no quorum of judges, the Secretary of the Division as the head of administration, the Assistant Secretary of the Division as an assistant to the tasks of the Secretary, the Judge in the Division as an entrusted judge, and the court official as an official person performing administrative duties. Currently, the division is located in the Supreme Court of Thailand in Bangkok. If you wish to know further information along with previous decisions of the court, you can find out at the website. Furthermore, with the cooperation between the division and the Konrad Adenauer Stiftung Thailand, there is a book of previous judgments of the Criminal Division for person holding political position of the Supreme Court. Thank you for watching. Goodbye.